Article 34.2, subparagraph A, subparagraph 2 of the model law provides for the procedural grounds which denies a party due process. The party is not given notice or denied the opportunity to present his case. The right to due process is set out in Article 18 of the model law, and it provides for a framework of equality of treatment of the parties and the right of the parties to fully present their cases, which includes, among others, the right to information of all submissions in the arbitration proceedings and the proper notice of the initiation of the arbitration proceedings. This slide sets out examples where parties are deprived of due process and therefore would have sufficient grounds to set aside. First, the lack of participation or representation. But this can only be invoked by parties if such was due to circumstances attributable to the arbitral tribunal or extraneous events beyond its control. It cannot be invoked if one voluntarily did not appear in the arbitration proceedings. So for example, in Canada, a party voluntarily boycotted the arbitration proceedings. The courts there found that there was no violation of due process. Another example is the lack of information about the arbitration and the constitution of the arbitral tribunal. It includes the failure to inform the party of the conformation of the presiding arbitral tribunal that was constituted. Another example is improper service of documents, which may violate the right of the party to be heard. And this may arise when the documents are delivered not to the present address of a party. For example, it was delivered to the last known address of the defendant, or when there is substituted service. Another is language, where the parties are unable to understand the language of the proceedings, except when such language has been explicitly agreed upon by the parties. Another example is failure to give a party a reasonable time to respond, or a refusal to hold oral hearings upon the request of a party. The failure to give a party a reasonable time to respond, or the refusal to hold oral hearings upon the request of a party may be grounds to set aside. The rejection of the evidence offered or presented is another example. Although here we note that generally, arbitral tribunals have the discretion to decide which evidence are relevant and which evidence should be admitted. A party's inability to comment on relevant evidence may also be a ground. A party should have the opportunity to comment on all facts and factual issues which may be relevant for the arbitral award. An independent investigation by the arbitral tribunal may also be an example for this ground. If this is made without informing of the parties, or when the parties could not even comment on the result of this independent investigation by the tribunal. Also, award on issues not indicated to the parties before rendering the award is an example of the violation of due process, where a tribunal based an award on a legal doctrine which has not been discussed during the proceedings, so as to give the parties the opportunity to make arguments and submit evidence on this legal doctrine.